everyone, Judicial Watch President Tom Fitton here with our weekly update on social media. A lot going on this week. We obviously had these big Supreme Court decisions on the vaccine mandates, major Judicial Watch victory for the rule of law and against leftist extremism, new lawsuits on Biden corruption in Afghanistan, and a lot to talk about in terms of Dr. Fauci and what he's been up to, plus the continued targeting of President Trump, or at least the past targeting of President Trump is again in our legal sites. First up, though, is a major Judicial Watch victory on behalf of the United States Constitution and the rule of law and anti-racism, as the left likes to say. Judicial Watch filed a lawsuit in October on behalf of a group in Asheville, North Carolina, who was objecting to a city-funded scholarship program that was limited by race, meaning it was a blacks-only scholarship program. And we sued on behalf of the WNC Citizens for Equality, whose members include high school students who were ineligible for this government-funded scholarship program only because they're not black. Well, it started back in May of last year. The city of Asheville entered into an agreement with another entity, a foundation, to establish and administer the City of Asheville Scholarship Fund. According to the agreement, the scholarship was to be awarded in perpetuity to black high school students within Asheville city schools, with special consideration given for black students pursuing a career in education. They previously, and this is all part of this kind of extremist, racialist agenda, the City Council in 2020, for instance, had previously approved what it called a reparations initiative that provided funding to programs geared towards increasing home ownership and business and career opportunities for black residents. So you had this inordinate and inappropriate focus on race-based awards of government money, which is outrageously illegal. So we filed this civil rights lawsuit back in, I think, October, challenging this outrageously unconstitutional violation of the civil rights of the residents and others of Asheville, North Carolina. Well, guess what? They settled and they stopped the discrimination. Just this week, on January 11th, the City Council of Asheville approved a resolution that removes the racial criteria for the scholarship. And this is the new language. The scholarship will give preference to applicants whose household members, including parents and or guardians, have a high school education or less. These applicants representing first-generation college students. So perfectly neutral. It doesn't focus, it doesn't give away money based on race. It opens the scholarship up to anyone of a certain background, no matter their race. And they even went further. There was another program that we hadn't even sued over that had racially discriminatory language for a scholarship program for educators and staff of the Asheville City Schools. And they agreed to make sure that that program also abided by the non-discrimination clause passed by the Asheville City Council. And in addition, they added specific language to make it clear that the programs couldn't discriminate on the basis of race. So boom, this is a great decision by the City Council. I got to give them credit for not fighting us and wasting taxpayer dollars and doing the right thing to quickly end the indefensible race-based scholarship programs. And our clients, as I said, a group of Asheville residents, including high school students, courageously challenged this blatantly discriminatory and illegal scholarship program in federal court. And as you might imagine, if you come forward and challenge this crazed leftist extremism that promotes racial discrimination, they accuse you of being a racist. So it's a brave thing to do, both for Judicial Watch and our clients, to come forward and promote the rule of law and the race-neutral application of the law. This federal lawsuit, and as I said, this is a remarkable settlement, really is a wake-up call, at least it ought to be. Of course, there are revolutionaries that are pushing this type of agenda throughout the land, so I don't know if they'll pay attention. But it should serve as a wake-up call to those activists and allied politicians pushing the extremist leftist agenda to segregate and discriminate based on race. And we were helped and partnered with the Legal Insurrection Foundation in this lawsuit. So this is just great news. This was a in-your-face attempt to violate federal and state laws and the Constitution that all prohibit racial discrimination in matters like this. You can't give out scholarships and exclude members of a race from obtaining a publicly funded scholarship. You just can't do it. And this is what the city of Asheville tried to get away with. We sued them in federal court and they backed down and they agreed to end the case, end the lawsuit. So the lawsuit's over. The settlement's been signed by agreeing to make sure that the scholarship money is available to all comers, no matter the race, and that they promise not to discriminate. So great victory for the rule of law, the Constitution, and the CRT agenda. This is part of it. CRT, so you know, but that whole rubric justifies discrimination on the basis of race. And those of us who oppose discrimination on the basis of race, we're battling the left on this, because right now they're trying to upend the whole infrastructure of law that prohibits discrimination on the basis of race. The irony is just incredible. So great news. We've got more cases on CRT. We got more cases challenging these attacks on discrimination laws, where, for instance, in California right now, we have lawyers in a state court challenging the illegal quota mandate requiring that boards of directors in California have a certain number of women in seats, meaning that there are seats on boards of directors for which men cannot apply. And the trial, I think I think this is the fourth week of the trial. So, it's one thing to complain about the left and what they're doing. It's quite another thing to go into court and vindicate the rule of law. And what's incredible here is that you have this outrageous violation of civil rights laws. The Justice Department is AWOL, a Civil Rights Division of the Justice Department. Where are they? Well, they support this, evidently, as indicated by their lack of action. And I remember during the Obama administration, the allegation was, and it was proven by the Inspector General that looked into some of this, that you had advocacy within the Justice Department Civil Rights Division that they believed that the civil rights laws are not designed to protect the rights of anyone but minorities. So if you were the wrong color, the rule of law related to civil rights protections that protected you from being discriminated on the basis of race, they would not advocate for you. They would not protect you. They would not go to court to protect you. And now we're seeing in certain states, they have decided that they would treat people, allow special treatments of COVID, make them available, these monoclonal antibodies or variations of that, to people based on race. Explicitly so. Blatant racial discrimination, encouraged in part by the FDA. So you've got all of the infrastructure of the left in the federal government, in the states, and in the case of Asheville and city, and certainly it's happening in the academy for some time, they've decided that they can discriminate on the basis of race or sex or other improper classifications. And it's Judicial Watch who's in court trying to defend and protect the rule of law and the civil rights of United States citizens. I mean, is this the left's goal, that we go back to all bets are off? You never know whether you're going to get educated or have the right to vote or gain access to government services or get access to health care based on your race? Is that their goal? See, it would seem so. Well, they suffered a significant setback, at least in Asheville, North Carolina, thanks to the excellent lawyering of Judicial Watch, the bravery of our clients, and you, those of you who support Judicial Watch's work that allows us to go into court and, as I always say, do the heavy lifting to defend the rule of law. So I appreciate your support in that regard. The other big news this week is, or are, the Supreme Court decisions related to the Biden vaccine mandates. Now, before the court were two big questions, and I guess there were two separate cases because I have two separate opinions. One was a vaccine mandate issued by OSHA, the Occupational Health and Safety Administration, that required more or less employers of with 100 or more employees to put into place a vaccine mandate. It was either you have a mandate or then you had some sort of crazy, if you didn't have the mandate, some crazy testing regime that was completely harassing. And as the Supreme Court ruled that the challenge to that is likely to succeed, and I'm kind of paraphrasing, and they allowed a stay issued by the lower court, which essentially is stopping the mandate from being implemented, to continue. So the big Biden vaccine mandate is dead for now. And it's unlikely to be resurrected, at least in its current form. Big victory for the rule of law, big victory for the Constitution. It was 6-3. So all of the Republican appointees, the conservatives on the court, or not so conservatives on the court, depending on your point of view, voted to stay the vaccine mandate. And the three leftists on the court obviously supported this unprecedented attack on the rights of American citizens by requiring to engage and take a medical treatment that's irreversible. And there are some key lines I'd like to review with you. And I encourage you to look at both decisions. They're available on the Supreme Court's website. And it gives you an idea of what the fight was about. And I'm going to say before I get into the detail here, the fight wasn't about the core constitutional issues that many of us are concerned about when you have governments either at the federal, state, or local level impose vaccine mandates. It was about whether the federal laws that Biden was using to justify his vaccine mandates allowed him to do what he suggested he had the power to do. And they found in the case of the law governing OSHA, he didn't. And this is kind of the craziness of it. They were purporting to cover, I may have said this already, 84.2 million Americans with this mandate. And as the court said, they were kind of painting with a broad brush. The regulation operates as a blunt instrument. It draws no distinction based on industry or risk of exposure to COVID-19. Thus, most lifeguards and linemen face the same regulations as do medics and meatpackers. And as I said, 84.2 million covered. And they're using the so-called emergency standard regulation that OSHA has in its rules and it's the law governing its powers as an excuse and pretext to impose this mandate. And the thinking is, look, if there's an emergency issue in a workplace, for instance, I don't know, a dangerous chemical, they can impose a specific mandate on a specific company or a specific industry that's narrowly tailored. And the concern that the conservatives on the court had is, if the Congress intended OSHA to allow this unprecedented assertion of power over 85 million people, Congress would have written it more explicitly. And you just can't pretend that a law that allows you to act in narrow circumstances allows you to act, practically speaking, without any notice or comment in this radical and extreme measure. And this is what would happen. Unvaccinated employees who do not comply with OSHA's rule must be removed from the workplace. Radical. And this wasn't an act that took place or activities that took place solely at work where there was a specific hazard and you needed to wear a hard hat or something. I mean, they were telling employees that in order to continue working, you had to submit to testing or more importantly, that employers could use the law to require vaccinations, medical treatment, as Justice Alito said in another case. Employers who've committed violations were facing up to $13,000 for a standard violation and $136,000 for a willful one. So it would have decimated companies who refused to comply. And this is the key quote. Applicants are likely to succeed on the merits of their claim. And that's kind of the standard for, issuing an injunction or a stay of this nature, or one of the standards. On the merits of their claim that the Secretary lacked authority to impose the mandate. Administrative agencies are creatures of statute, meaning law, written law. They accordingly possess only the authority that Congress has provided. The Secretary has ordered 84 million Americans to either obtain a COVID-19 vaccine or undergo weekly medical testing at their own expense. This is no everyday exercise of federal power, the court writes. It is instead a significant encroachment into the lives and health of a vast number of employees. And this is a quoting from another case. We expect Congress to speak clearly when authorizing an agency to exercise powers of vast economic and political significance. There can be little doubt that OSHA's mandate qualifies as an exercise of such authority and therefore is unlawful and contrary to, in my view, the Constitution at least. But you see that in that decision. What's the mirror of that language? Is that Biden was trying to be a dictator. He was acting as a despot. He was issuing law. He was issuing regulations by fiat that had no basis in the Constitution or his authority as President of the United States. He's supposed to enforce the laws. He can't write them and make them up as he goes along. And we went from, it was bad under Obama with a pen and a phone. And sometimes Trump, he kind of pushed the boundaries of executive decision-making and authority. Biden, he's completely out of control. And thankfully, under our system of government, the courts are doing some good work in keeping him under control, because this vaccine mandate would have been an extraordinary expansion of executive power that would have eviscerated constitutional controls on the presidency in a way that would have put all of our civil rights and our personal liberties at risk every time there was, quote, an emergency that Biden thought he needed to, or someone else thought he needed to act to thwart. So that was a great decision. And then concurrently, same time, they issued another decision. That was not a great decision. This was on another Biden vaccine mandate issued by the Health and Human Services related to Medicare and Medicaid programs. And the Secretary announced that in order to receive Medicare and Medicaid funding, participating facilities must ensure that their staff, unless exempt for medical or religious reasons, are vaccinated against COVID-19. Now, in this case, the lower courts correctly enjoined the rule, stayed it, stopped it, but the Biden administration appealed, and unfortunately, the Supreme Court removed the stay so the policy can move forward. Justices Kavanaugh and Chief Justice Robert agreed with the three leftists to allow HHS to again, exercise unprecedented power to require anyone who works in medical facilities, and I'm not quite sure the specifics of what's covered there in terms of what qualifies as a facility that's covered under this definition of Medicare or Medicaid funding. But depending on the numbers, it's either 10 or 17 million people. Either way, it's too many Americans who are under the thumb of the government now as a result of this decision. It was a close decision. The other one was 6-3. This one was 5-4. And thankfully, I don't know, maybe the record underneath, this doesn't end the case because the case can continue to litigate. It certainly doesn't augur well for the challengers who are seeking to defend and vindicate the liberty of citizens who work in these healthcare settings. But maybe they'll fix it, and they'll come up with information that persuades the court to change its mind in this regard when it ultimately, if it does, rule on the merits. And this is the heart of it here, and I encourage you to read the full dissents. Today's decision, because one of the things they did again was issue this emergency ruling. An emergency that took place almost a year after the vaccines were made available. So all of a sudden it became an emergency. Everyone had a vaccine, and therefore they didn't have to follow the normal procedures. Today's decision will ripple through administrative agencies' future decision-making. The executive branch already touches nearly every aspect of Americans' lives, and concluding that CMS, which is the the health agency at the federal level that issued this, had good cause to avoid notice and comment rulemaking, the court shifts the presumption against compliance with procedural strictures from the unelected agency to the people they regulate. So typically, when a regulation of this nature is issued, and given its wide applicability and dramatic change in the relationship between government and the American people, it's typically subject, in the least, assuming that there's any authority to even consider issuing it, to notice and comment so the American people can respond. And the agency by law is supposed to respond to those concerns. They didn't do that here. Neither the agency nor the court, meaning the 5 justices who upheld this abuse, articulates a limiting principle for why, after an unexplained and unjustified delay, an agency can regulate first and listen later. And this is just tremendous language, and I encourage you to remember it and use it. And then put more than 10 million healthcare workers to the choice of their jobs or irreversible medical treatment. Now, how can I improve on that? So that's where we stand. The big OSHA mandate is dead, probably for now, meaning forever. The healthcare vaccine mandate for healthcare workers is alive. So we got to be concerned about those Americans because their liberty is restricted now in a way it wasn't restricted 2 days ago. The good news is 85 million Americans are freer today than they were 2 days ago. And there are other vaccine mandates that Biden has issued that are still before the courts, related to federal employees, related to contractors. So if there's one contract that you have with the government, no matter your circumstances, there's a vaccine mandate tied to it. And then, of course, are always abused by the left. Military are facing abusive vaccine mandates. So there are constitutional issues, and I'm not going to lecture you as to what they are. It's called freedom, liberty. You have core rights in your person that are protected by the Constitution. And in this case, the courts didn't even really get to whether these regulations made any sense scientifically. And I'm hoping the lower courts get to that because I don't think they could survive any rational analysis. I mean, it's one thing to have the Supreme Court say, there's this health emergency and everyone thinks this vaccine works, and therefore we're going to allow the government to require people in healthcare settings use it to protect themselves and patients. Well, what if the vaccine doesn't work? I mean, the news is from Fauci this week, everyone's going to get COVID. At least the Omicron version of it. How does the vaccine mandate stand up under that logic? And the government can't go and tell you, you need to start flapping your arms before you go to work because it makes you safer. There's got to, obviously that's absurd. And no court's going to uphold that. And I hope that's the case with this vaccine mandate. So what is Judicial Watch doing? Well, we're doing something the government hates, which is asking questions about how they approved the vaccines to begin with. As I've discussed here previously, the American people have a right to know about the safety and efficacy of these vaccines, especially in light of their government, in the case of the Biden administration, deciding to impose vaccine mandates on entire swaths of the population. And so what Judicial Watch is doing is that we have litigation and Freedom of Information Act requests to try to get more information about what went on in terms of how the vaccine was developed and just basic information and basic data that, contrary to what the government and its media allies tell you, hasn't been made public, as in our view, the law requires. So we will try to vindicate the rule of law, obviously, generally on vaccine mandates, while holding the government accountable for how they created this in a way that may place people at harm or just raise questions about the processes that American people just have a right to know anyway, because it's their government. So along those lines, one of the I think least trustful public official in our nation's in our nation's capital right now is Dr. Anthony Fauci. He's a government official. He's not elected. He's appointed. He's, I think, a special advisor. I don't know what the exact title is. Highest paid man in the federal government. Highest paid employee in the federal government, the reports are. And we're holding him accountable. There was a big fight this week over a matter that Judicial Watch is in federal court over on behalf of our client, OpenTheBooks.com, which is a transparency organization that seeks to uncover government spending and waste, fraud, and abuse. As you might imagine, they're great friends of ours because they love FOIA like we do and try to get the government to be transparent about what it's up to. So they had initially asked for records about Fauci's financial disclosures. All these questions about how much he was getting paid, what his investments were, all sorts of questions that could have been answered by timely release of his financial disclosure records, and that wasn't being done. And they had asked for these records back last year. They got some records under the Freedom of Information Act, and they went radio silent, his agency did, in terms of making this information available. And so Senator, now I'm forgetting the senator's name, Senator Marshall, a senator from Kansas, he did something that is not allowed in Washington, D.C. He actually asked Fauci a tough question. He said, Dr. Fauci, can you promise to release your disclosures, your financial disclosures, by the end of the week? This is stuff that's already on file, in theory. And his response was remarkably antagonistic, basically calling him stupid, saying, oh, they're available, just have to ask, all sorts of distraction. He didn't commit to making them available. And under his breath, at the end of the questioning, he called the senator a moron. So that's Fauci's contempt for the elected representatives. I mean, it's like a general calling a senator a moron. He's not an equal legally. He's an equal as a citizen, but these senators are responsible for providing oversight over him. They appropriate his funds, and he goes in and calls them morons. I mean, that's misconduct. That's government misconduct, and he should be held accountable for it. And so contrary to what Fauci said, they're not easily accessible. We wouldn't be in federal court over it. And what's interesting is the day after, the government came back to us and they told us, and obviously our client, that, oh, we gave you those records under FOIA last year. We shouldn't have done it under FOIA. You had to ask for them under another law. And here's the form. Fill it out. So they're playing shell games after delaying the release of this information. they play shell games and, in my view, come in to try to rescue Fauci. So what's really great is that Senator Marshall, after Fauci showed the contempt for the people's representatives, he announced that he was going to introduce legislation requiring public disclosure of this information in a more timely way. And he called it the Fouchy Act, which is an acronym. It's a great acronym, the Financial Accountability for Uniquely Compensated Individuals, the Fouchy Act. So I think that's going to be introduced soon. But so our case continues in federal court. We want the records. And Fauci's dissembling isn't going to distract us. And so what is Judicial Watch's response when government officials start making noises to obstruct and obfuscate? Well, we just keep on pushing. We keep on fighting. And indeed, we filed a new lawsuit on behalf of our client, OpenTheBooks.com, this week against Fauci's agency for his calendars. We want his calendar records. Our client, well, actually, we both do. We filed the FOIA request jointly. We want his calendar entries from the early days of the pandemic. We want to know who he was meeting with. He's a government official. We have a right to know. And of course, the government was stonewalling the release of this information, contrary to law. So every time you hear Judicial Watch does a FOIA lawsuit, it means somewhere an agency broke the law. They refused to follow the FOIA law. So we had the federal government breaking federal law repeatedly. So this is what we asked for. This is our request. All calendars or calendar entries for Dr. Anthony Fauci, including calendars maintained on Fauci's behalf. For calendars or calendar entries created electronically, the record should include the names of invitees, notes, and other attachments for a given entry. The time frame for the request was identified as November 1st, 2019 to March 31st, 2020. So let's see, that's 1 month, 2 months, 5 months of calendars. That would take an afternoon to review and process under FOIA. It'd take an afternoon. And it's months later and we don't have the records. So what is he hiding? And by process, it means that, look, I don't want to know if he's meeting with family members and, any doctor's appointments. We don't have a right to know that. So the law allows the government to withhold that information from us, and it's blacked out. We don't want to know people's phone numbers. They're blacked out. Again, it takes an afternoon to do it. Maybe 2 days, maybe 3 days. The law gives them 20 days, and they didn't follow it. And we're suing. And this is on top of all the other lawsuits we have that have exposed Fauci's mendaciousness related to COVID in China and gain-of-function research. You may have seen news by our friends at Project Veritas from a whistleblower who used to work at the Pentagon, worked for this Defense Advanced Research Agency, DARPA, where they knew that the group that Fauci was funding, EcoHealth Alliance, had earlier gone to the Pentagon and proposed gain-of-function research. That was rejected because it was gain-of-function research and it was dangerous. So what did this guy analyze? He said they took this proposal more or less and laundered it, brought it over to Fauci's agency, and they funded it. Well, the proposal we exposed. Gain-of-function. And Fauci was told about it almost immediately, and they had been sitting on it for a year before they released it publicly, thanks to Judicial Watch's lawsuit. And documents showing them being in bed with China, the Chinese communists, and all the money that they were giving them, more than they were admitting to publicly. All thanks to Judicial Watch. Judicial Watch is doing more to investigate Fauci, Wuhan, COVID, basic information about the worst pandemic in American history, we're told, than all the king's horses and all the king's men in Congress, the media, certainly the administration's in cover-up mode. So I encourage you to follow and support our work in this regard. And speaking of one of the worst scandals in American history, the worst military scandal in American history, the worst defeat in American history, is Biden's surrender in Afghanistan. And Judicial Watch's FOIA previously uncovered that the Special Inspector General for Afghan Reconstruction was told by the State Department political operation under Biden to delete reports documenting monies wasted in Afghanistan and monies that would have shown the value of the equipment and training that the Taliban was then benefiting from as a result of Biden's surrender to them. Not only did they tell the CIGAR, the Special Inspector General, to take reports down, but it turns out other agencies were told to take upwards of over 420 reports down. The worst censorship that I've ever seen of a scandal. Just explicit. Even the fact that we got the documents, we didn't have to sue for them, shows that the Inspector General was angry and released them to us. That's how I read it. And you could see in the emails that he objected to it. He thought it was in violation of the law because Inspector General reports are supposed to be public. And of course, the media doesn't care. They completely move on. There are Americans still stuck in Afghanistan, and they don't care. Well, Judicial Watch does, so we sued the State Department for records about that censorship push to cover up the breadth and scope of Biden's and generally other administrations' wasted monies in Afghanistan as a result of the surrender and the danger to America that remains in terms of the equipment and that has been left behind, military, and the training that they were able to benefit from, because now we've trained the other side, practically speaking, because now they control the country. And there's a second important lawsuit, and this is the real nasty part of what Biden did, we're concerned he did. That's why we're suing. We're asking the question: all records related to any actual or proposed payments to the government of Afghanistan and or any other member or associate of the Taliban related to the departure from Afghanistan of any U.S. citizen or other individuals authorized by the U.S. government to depart. This includes, but is not limited to, all fees related to the use of any airport for such departure. So were we effectively bribing the Taliban or paying ransom to get people out using tax dollars? It would be par for the course. I mean, indeed, this week it was announced the Biden administration is authorizing, I think through the USAID, which is one of the most corrupt agencies in government, since it's the vehicle through which the corruption that you read about in other parts of the world are funded. USAID, their job, my view, is to fund government corruption and local tyrannical corruption in places around the world, even though they say it's for humanitarian purposes. So similarly, we've got $300 million now, I think it's $300 million plus, at least, going to Afghanistan. Don't worry, it's going to independent agencies. Ha! Might as well write a check to Taliban Inc. in Afghanistan with that money. So I just love that Judicial Watch is, again, doing the heavy lifting that no one else wants to do in Afghanistan. No one's been fired. No one's resigned. As far as I'm concerned, what Biden did in Afghanistan is impeachable. And as I said in our statement, we caught the Biden administration red-handed trying to cover up its Afghanistan disaster. As Americans reportedly remain stranded in Afghanistan, the Biden administration has yet to come clean about the tens of billions of military resources potentially lost to the Taliban and about whether the government paid or considered paying the Taliban during Biden's deadly and disastrous surrender. We already have a lawsuit we want photos and videos of the plane. Remember the plane where the people were trying to grab onto it and were on it as it was flying away? We want to see what went on. Just basic information that Congress isn't doing anything about and the media doesn't care about. And the other big scandal, obviously, is the deep state's targeting of President Trump, which continues in other ways today, now through the Pelosi-Rump Committee, the illegitimate committee that is being used to try to jail Americans. Right now, there's a subpoena that's been issued to big tech for content that would cover potentially the posts of millions of Americans. They're taking countless they're demanding from big tech the posts of Americans on social media about matters. It's, in my view, matters. Anyone who opposed the election, anyone who opposed the election schemes that the Democrats were promoting, anyone that opposed or promoted integrity in the elections would be targeted here. Anyone that big tech censored, their records might be sent over. So you, dear viewer, you, dear listener, may be the target of the January 6th Rump Committee that Pelosi set up. And of course, it's all about hating Trump, keeping him controversial in a negative way because they see him as a threat, because he's the leader of the opposition in some respects, and obviously a potential candidate to challenge Joe Biden again. And one of the worst scandals in American history was the seditious activities of the government that the president had that the president was running. They were trying to overthrow him, undermine him, and undermine the will of the American people. In one of these instances, it looked like you had General Mark Milley targeting President Trump in a conversation with the head of the CIA. I mean, so you have these leftists talk about coups, and then you have the head of the military, I guess he's not the head of the military, but a senior official in the military, one of the most senior, chairman of the Joint Chiefs of Staff, president's number one military advisor in many matters, conspiring and yapping with Gina Haspel, the head of the CIA, because they didn't like President Trump's stand on the elections. So they started, according to one report, there was one conversation in which Trump was attacked as being part of a coup. These are his own people. You have the general and a top general in the country and the head of the CIA. I mean, that's X-Files conspiracy type of stuff. And they're doing it. And they're proud of it because they're telling other people this is what we talked about. So we asked for records from the CIA about this alleged conversation or reported conversation. And we haven't gotten any answers. So we sued on December 31st. 3 months we waited and we sued. How many records could there be about one conversation? Not many. And it shows you they're in cover-up mode. It ought to be disturbing to all Americans that the head of the CIA and the chairman of the Joint Chiefs of Staff were reportedly conspiring against the President of the United States. Our new lawsuit will hopefully ferret out the truth about any plots to undermine President Trump by the military and the CIA. Someone's got to defend our constitutional structure, and Judicial Watch is. Through this basic Freedom of Information Act, investigations and litigation. So, a lot going on. I didn't think I'd be able to stay energetic through this, but I'm outraged about all of this. Our liberties are under attack. The left is out of control. They want to blow up our Constitution. They want to blow up our laws against discrimination so they can destroy the country through segregation based on race and discrimination based on race. They leave our Americans behind. They surrender to terrorists in a crazed way. Worst thing that's ever happened in American history, in my view. And then you have this conspiracy among the elites against our elected president. These are trying times for our country, and strength is needed, and Judicial Watch is providing that strength, thanks in, as I say, large part to supporters like you. And if you're not supporting us, you ought to, because I don't know where the country would be for Judicial Watch's work. So thank you, have a great week, and I'll see you here next time on the Judicial Watch Weekly Update.